Hello, everyone. We're going to wrap up Dred Scott today. Fort Snelling was within the territory of Wisconsin, and these laws were extended over it. The Indian title to that site for a military post had been acquired from the Sioux Nation as early as September 23rd, 1805. And until the erection of the territorial government, the persons at that post were governed by the rules and articles of war and such laws of the United States, including the 8th section of the Act of March 6, 1820, prohibiting slavery, as were applicable to their condition, but after the erection of the territory and the extension of the laws of the United States and the laws of Michigan over the whole of the territory, including this military post, the persons residing there were under the dominion of those laws in all particulars to which the rules and articles of war did not apply. It thus appears that by these acts of Congress, not only was a general system of municipal law borrowed from the state of Michigan, which did not tolerate slavery, but it was positively enacted that slavery and involuntary servitude, with only one exception specifically described, should not exist there. It is not simply that slavery is not recognized and cannot be aided by the municipal law. It is recognized for the purpose of being absolutely prohibited and declared incapable of existing within the territory, save in the instance of a fugitive slave. It would not be easy for the legislature to employ more explicit language to signify its will that the status of slavery should not exist within the territory than the words found in the Act of 1820 and in the Ordinance of 1787. And if any doubt could exist concerning their application to cases of masters coming into the territory with their slaves to reside, that doubt must yield to the inference required by the words of exception. That exception is, of cases of fugitive slaves. An exception from a prohibition marks the extent of the prohibition, for it would be absurd, as well as useless, to accept from a prohibition a case not contained within it. I must conclude, therefore, that it was the will of Congress that the state of involuntary servitude of a slave, coming into the territory with his master, should cease to exist. The Supreme Court of Missouri so held in Rachel v. Walker, which was the case of a military officer going into the territory with two slaves. But it is a distinct question whether the law of Missouri recognized and allowed effect to the change wrought in the status of the plaintiff by force of the laws of the territory of Wisconsin. I say the law of Missouri because a judicial tribunal in one state or nation can recognize personal rights acquired by force of the law of any other state or nation, only so far as it is the law of the former state that those rights should be recognized. But in the absence of positive law to the contrary, the will of every civilized state must be presumed to be to allow such effect to foreign laws as is in accordance with the settled rules of international law. And legal tribunals are bound to act on this presumption. It may be assumed that the motive of the state in allowing such operation to foreign laws is what has been termed comity, but as has justly been said, per Chief Justice Taney, it is the comity of the state, not of the court. The judges have nothing to do with the motive of the state. Their duty is simply to ascertain and give effect to its will. And when it is found by them that its will to depart from a rule of international law has not been manifested by the state, they are bound to assume that its will is to give effect to it. Undoubtedly, every sovereign state may refuse to recognize a change, wrought by the law of a foreign state, on the status of a person, while within such foreign state, even in cases where the rules of international law require that recognition. Its will to refuse such recognition may be manifested by what we term status law, or by the customary law of the state. It is within the province of its judicial tribunals to inquire and adjudge whether it appears from the statute or customary law of the state to be the will of the state to refuse to recognize such changes of status by force of foreign law, as the rules of the law of nations require to be recognized. But in my opinion, it is not within the province of any judicial tribunal to refuse such recognition from any political considerations or any view it may take of the exterior political relations between the state and one or more foreign states, or any impressions it may have that a change of foreign opinion and action on the subject of slavery may afford a reason why the state should change its own action. To understand and give just effect to such considerations, and to change the action of the state in consequence of them, are functions of diplomatists and legislatures, not of judges. The inquiry to be made on this part of the case is therefore whether the state of Missouri has, by its statute or its customary law, manifested its will to displace any rule of international law applicable to a change of the status of a slave by foreign law. I have not heard it suggested that there was any statute of the state of Missouri bearing on this question. The customary law of Missouri is the common law, introduced by statute in 1816, and the common law, as Blackstone says, adopts in its full extent the law of nations and holds it to be a part of the law of the land. I know of no sufficient warrant for declaring that any rule of international law concerning the recognition in that state of a change of status wrought by an extraterritorial law has been displaced or varied by the will of the state of Missouri. I proceed then to inquire what the rules of international law prescribe concerning the change of status of the plaintiff wrought by the law of the territory of Wisconsin. It is generally agreed by writers upon international law, and the rule has been judicially applied in a great number of cases, that wherever any question may arise concerning the status of a person, it must be determined according to that law which has next previously rightfully operated on and fixed that status. And further, that the laws of a country do not rightfully operate upon and fix the status of persons who are within its limits in interior, or who are abiding there for definite temporary purposes, as for health, curiosity, or occasional business. That these laws, known to writers on public and private international law as personal statutes, operate only on the inhabitants of the country. Not that it is or can be denied that each independent nation may, if it thinks fit, apply them to all persons within their limits. But when this is done, not in conformity with the principles of international law, other states are not understood to be willing to recognize or allow effect to such applications of personal statutes. It becomes necessary, therefore, to inquire whether the operation of the laws of the territory of Wisconsin upon the status of the plaintiff was or was not such an operation as these principles of international law require other states to recognize and allow effect to. And this renders it needful to attend to the particular facts and circumstances of this case. It appears that this case came on for trial before the circuit court and a jury upon an issue, in substance, whether the plaintiff, together with his wife and children, were the slaves of the defendant. The court instructed the jury that, upon the facts in this case, the law is with the defendant. This withdrew from the jury the consideration and decision of every matter of fact. The evidence in the case consisted of written admissions signed by the counsel of the parties. If the case had been submitted to the judgment of the court upon an agreed statement of facts entered of record in place of a special verdict, it would have been necessary for the court below and for this court to pronounce its judgment solely on those facts, thus agreed, without inferring any other facts therefrom. By the rules of the common law applicable to such a case, and by force of the 7th article of the amendments of the Constitution, this court is precluded from finding any fact not agreed to by the parties on the record. No submission to the court on a statement of facts was made. It was a trial by jury in which certain admissions made by the parties were the evidence. The jury were not only competent, but were bound to draw from that evidence every inference which, in their judgment, exercised according to the rules of law, it would warrant. The circuit court took from the jury the power to draw any inferences from the admissions made by the parties, and decided the case for the defendant. This course can be justified here, if at all, only by its appearing that upon the facts agreed, and all such inferences of fact favorable to the plaintiff's case, as the jury might have warranted in drawing from those admissions, the law was with the defendant. Otherwise, the plaintiff would be deprived of the benefit of his trial by jury, by whom, for aught we can know, those inferences favorable to this case would have been drawn. The material facts agreed bearing on this part of the case are that Dr. Emerson, the plaintiff's master, resided about 2 years at the military post of Fort Snelling, being a surgeon in the Army of the United States, his domicile of origin being unknown, and what, if anything, he had done to preserve or change his domicile prior to his residence at Rock Island, being also unknown. Now, it is true that under some circumstances, the residence of a military officer at a particular place in the discharge of his official duties does not amount to the acquisition of a technical domicile, but it cannot be affirmed with correctness that it never does. There being actual residence, and this being presumptive evidence of domicile, all the circumstances of the case must be considered before a legal conclusion can be reached that his place of residence is not his domicile. If a military officer stationed at a particular post should entertain an expectation that his residence there would be indefinitely protracted, and in consequence should remove his family to the place where his duties were to be discharged, form a permanent domestic establishment there, exercise there the civil rights, and discharge the civil duties of an inhabitant, while he did no act and manifested no intent to have a domicile elsewhere, I think no one would say that the mere fact that he was himself liable to be called away by the orders of the government would prevent his acquisition of a technical domicile at the place of the residence of himself and his family. In other words, I do not think a military officer incapable of acquiring a domicile. This being so, this case stands thus. There was evidence before the jury that Emerson resided about 2 years at Fort Snelling, in the territory of Wisconsin. This may or may not have been with such intent as to make it his technical domicile. The presumption is that it was. It is so laid down by this court in Ennis v. Smith, and the authorities in support of the position are there referred to. His intent was a question of fact for the jury. The case was taken from the jury. If they had power to find that the presumption of the necessary intent had not been rebutted, we cannot say on this record that Emerson had not his technical domicile at Fort Snelling, but for reasons which I shall now proceed to give. I do not deem it necessary to this case to determine the question of the technical domicile of Dr. Emerson. It must be admitted that the inquiry whether the laws of a particular country has rightfully fixed the status of a person, so that, in accordance with the principles of international law, that status should be recognized in other jurisdictions, ordinarily depends on the question whether the person was domiciled in the country whose laws are asserted to have fixed his status. But in the United States, questions of this kind may arise, where an attempt to decide solely with reference to technical domicile, tested by the rules which are applicable to changes of places of abode from one country to another, would not be consistent with sound principles, and, in my judgment, this is one of those cases. The residence of the plaintiff, who was taken by his master Dr. Emerson as a slave from Missouri to the state of Illinois, and thence to the territory of Wisconsin, must be deemed to have been, for the time being, and until he asserted his own separate intention, the same as the residence of his master, and the inquiry whether the personal statutes of the territory were rightfully extended over the plaintiff, and ought, in accordance with the rules of international law, to be allowed to fix his status, must depend upon the circumstances under which Dr. Emerson went into that territory, and remained there, and upon the further question whether anything was there rightfully done by the plaintiff to cause those personal statutes to operate on him. Dr. Emerson was an officer in the Army of the United States. He went into the territory to discharge his duty to the United States. The place was out of the jurisdiction of any particular state, and within the exclusive jurisdiction of the United States. It does not appear where the domicile of origin of Dr. Emerson was, nor whether or not he had lost it, and gained another domicile, nor of what particular state, if any, he was a citizen. On what ground can it be denied that all valid laws of the United States, constitutionally enacted by Congress for the government of the territory, rightfully extended over an officer of the United States and his servant who went into the territory to remain there for an indefinite length of time, to take part in its civil or military affairs? They were not foreigners coming from abroad. Dr. Emerson was a citizen of the country, which had exclusive jurisdiction over the territory, and not only a citizen, but he went there in a public capacity in the service of the same sovereignty which made the laws, whatever those laws might be, whether of the kind denominated personal statutes or not, so far as they were intended by the legislative will, constitutionally expressed, to operate on him and his servant, and on the relations between them. They had a rightful operation, and no other state or country can refuse to allow that those laws might rightfully operate on the plaintiff and his servant, because such a refusal would be a denial that the United States could, by laws constitutionally enacted, governed their own servants, residing on their own territory over which the United States had the exclusive control, and in respect to which they are an independent sovereign power. Whether the laws now in question were constitutionally enacted, I repeat once more, is a separate question. But assuming that they were, and that they operated directly on the status of the plaintiff, I consider that no other state or country could question the rightful power of the United States so to legislate, or, consistently with the settled rules of international law, could refuse to recognize the effects of such legislation upon the status of their officers and servants as valid everywhere. This alone would, in my apprehension, be sufficient to decide this question. But there are other facts stated on the record which should not be passed over. It is agreed that, in the year 1836, the plaintiff, while residing in the territory, was married, with the consent of Dr. Emerson, to Harriet, named in the declaration as his wife, and that Eliza and Lizzie were the children of that marriage, the first named having been born on the Mississippi River, north of the line of Missouri, and the other having been born after their return to Missouri. And the inquiry is, whether, after the marriage of the plaintiff in the territory, with the consent of Dr. Emerson, any other state or country can, consistently with the settled rules of international law, refuse to recognize and treat him as a free man, when suing for the liberty of himself, his wife, and the children of that marriage. It is in reference to his status, as viewed in other states and countries, that the contract of marriage and the birth of children becomes strictly material. At the same time, it is proper to observe that the female to whom he was married, having been taken from the same military post of Fort Snelling as a slave, and Dr. Emerson claiming also to be her master at the time of her marriage, her status and that of the children of the marriage are also are also affected by the same considerations. If the laws of Congress governing the territory of Wisconsin were constitutional and valid laws, there can be no doubt these parties were capable of contracting a lawful marriage, attending with all the usual civil rights and obligations of that condition. In that territory, they were absolutely free persons, having full capacity to enter into the civil contract of marriage. It is a principle of international law, settled beyond controversy in England and America, that a marriage, valid by the law of the place where it was contracted, and not in fraud of the law of any other place, is valid everywhere, and that no technical domicile at the place of the contract is necessary to make it so. If, in Missouri, the plaintiff were held to be a slave, the validity and operation of his contract of marriage must be denied. He can have no legal rights, of course, not those of a husband and father. And the same is true of his wife and children. The denial of his rights is the denial of theirs. So that, though lawfully married in the territory, when they came out of it into the state of Missouri, they were no longer husband and wife. And a child of that lawful marriage, though born under the same dominion where its parents contracted a lawful marriage, is not the fruit of that marriage, nor the child of its father, but subject to the maxim partus sequitur ventrum. It must be borne in mind that in this case there is no ground for the inquiry, whether it be the will of the state of Missouri not to recognize the validity of the marriage of a fugitive slave, who escapes into a state or country where slavery is not allowed, and there contracts a marriage. Or the validity of such a marriage, where the master, being a citizen of the state of Missouri, voluntarily goes with his slave into a state or a country which does not permit slavery to exist, and the slave there contracts marriage without the consent of his master. For in this case, it is agreed, Dr. Emerson did consent, and no further question can arise concerning his rights, so far as their assertion is inconsistent with the validity of the marriage. Nor do I know of any ground for the assertion that this marriage was in fraud of any law of Missouri. It has been held by this court that a bequest of property by a master to his slave, by necessary implication, entitles a slave to his freedom, because only as a free man could he take and hold the bequest. It has also been held that when a master goes with his slave to reside for an indefinite period in a state where slavery is not tolerated, this operates as an act of manumission, because it is sufficiently expressive of the consent of the master that the slave should be free. What then shall we say of the consent of the master, that the slave may contract a lawful marriage, attended with all the civil rights and duties which belong to that relation, that he may enter into a relation with none but a free man can assume, a relation which involves not only the rights and duties of the slave, but those of the other party to the contract, and of their descendants to the remotest generation. In my judgment, there can be no more effectual abandonment of the legal rights of a master over his slave than by the consent of the master that the slave should enter into a contract of marriage in a free state, attended by all the civil rights and obligations which belong to that condition. And any claim by Dr. Emerson of any one claiming under him, the effect of which is to deny the validity of this marriage and the lawful paternity of the children born from it, wherever asserted, is, in my judgment, a claim inconsistent with good faith and sound reason, as well as with the rules of international law. And I go further. In my opinion, a law of the state of Missouri, which should thus annul a marriage lawfully contracted by these parties while resident in Wisconsin, not in fraud of any law of Missouri or of any right of Dr. Emerson, who consented thereto, would be a law impairing the obligation of a contract and within the prohibition of the Constitution of the United States. To avoid misapprehension on this important and difficult subject, I will state distinctly the conclusions at which I have arrived. They are: first, the rules of international law respecting the emancipation of slaves and by the rightful operation of the laws of another state or country upon the status of the slave, while resident in such foreign state or country, are part of the common law of Missouri, and have not been abrogated by any statute law of that state. Second, the laws of the United States, constitutionally enacted, which operated directly on and changed the status of a slave coming into the territory of Wisconsin with his master, who went thither to reside for an indefinite length of time in the performance of his duties as an officer of the United States, had a rightful operation on the status of the slave, and it is in conformity with the rules of international law that this change of status should be recognized everywhere. Third, the laws of the United States in operation in the territory of Wisconsin at the time of the plaintiff's residence there did act directly on the status of the plaintiff and change his status to that of a free man. Fourth, the plaintiff and his wife were capable of contracting and, with the consent of Dr. Emerson, did contract a marriage in that territory, valid under its laws, and the validity of this marriage cannot be questioned in Missouri, save by showing that it was in fraud of the laws of that state, or of some right derived from them, which cannot be shown in this case, because the master consented to it. Fifth, that the consent of the master that his slave, residing in a country which does not tolerate slavery, may enter into a lawful contract of marriage, attended with the civil rights and duties which belong to that condition, is an effectual act of emancipation, and the law does not enable Dr. Emerson or any one claiming under him to assert a title to the married persons as slaves, and thus destroy the obligation of the contract of marriage, and bastardize their issue, and reduce them to slavery. But it is insisted that the Supreme Court of Missouri has settled this case by its decision in Scott v. Emerson, and that this decision is in conformity with the weight of authority elsewhere, and with sound principles. If the Supreme Court of Missouri had placed its decision on the ground that it appeared Dr. Emerson never became domiciled in the territory, and so its laws could not rightfully operate on him and his slave, and the facts that he went there to reside indefinitely as an officer of the United States, and that the plaintiff was lawfully married there, with Dr. Emerson's consent, were left out of view, the decision would find support in other cases, and I might not be prepared to deny its correctness. But the decision is not rested on this ground. The domicile of Dr. Emerson in that territory is not questioned in that decision, and it is placed on the broad denial of the operation in Missouri of the law of any foreign state or country upon the status of a slave, going with his master from Missouri into such foreign state or country, even though they went thither to become and actually became permanent inhabitants of such foreign state or country, the laws whereof acted directly on the status of the slave, and changed his status to that of a free man. To the correctness of such a decision I cannot assent. In my judgment, the opinion of the majority of the court in that case is in conflict with its previous decisions, with the great weight of judicial authority in other slaveholding states, and with fundamental principles of private international law. Mr. Chief Justice Gamble, in his dissenting opinion in that case, said, I regard the question as conclusively settled by repeated adjudications of this court, and if I doubted or denied the propriety of those decisions, I would not feel myself any more at liberty to overturn them than I would any other series of decisions by which the law upon any other question had been settled. There is with me nothing in the law of slavery which distinguishes it from the law on any other subject, or allows any more accommodation to the temporary excitements which have gathered around it. But in the midst of all such excitement, it is proper that the judicial mind, calm and self-balanced, should adhere to principles established when there it was no feeling to disturb the view of the legal questions upon which the rights of parties depend. In this state, it has been recognized from the beginning of the government as a correct position in law that the master who takes his slave to reside in a state or territory where slavery is prohibited thereby emancipates his slave. Chief Justice Gamble has also examined the decisions of the courts of other states in which slavery is established, and finds them in accordance with these preceding decisions of the Supreme Court of Missouri to which he refers. It would be a useless parade of learning for me to go over the ground which he has so fully and ably occupied. But it is further insisted we are bound to follow this decision. I do not think so. In this case, it is to be determined what laws of the United States were in operation in the territory of Wisconsin, and what was their effect on the status of the plaintiff. Could the plaintiff contract a lawful marriage there? Does any law of the state of Missouri impair the obligation of that contract of marriage, destroy his rights as a husband, bastardize the issue of the marriage, and reduce them to a state of slavery? These questions, which arise exclusively under the Constitution and laws of the United States, this court, under the Constitution and laws of the United States, has the rightful authority finally to decide. And if we look beyond these questions, we come to the consideration whether the rules of international law, which are part of the laws of Missouri, until displaced by some statute not alleged to exist, do or do not require the status of the plaintiff, as fixed by the laws of the territory of Wisconsin, to be recognized in Missouri. Upon such a question, not depending on any statute or local usage, but on principles of universal jurisprudence, this court has repeatedly asserted it could not hold itself bound by the decisions of state courts, however great respect might be felt for their learning, ability, and impartiality. Some reliance has been placed on the fact that the decision in the Supreme Court of Missouri was between these parties, and the suit there was abandoned to obtain another trial in the courts of the United States. In Homer v. Brown, this court made a decision upon the construction of a devise of lands, in direct opposition to the unanimous opinion of the Supreme Court of Massachusetts, between the same parties respecting the same subject matter, the claimant having become non-suit in the state court in order to bring his action in the Circuit Court of the United States. I did not sit in that case, having been of counsel for one of the parties while at the bar, but on examining the report of the argument of the counsel for the plaintiff in error, I find they made the point that this court ought to give effect to the construction put upon the will by the state court, to the end that rights respecting lands may be governed by one law, and that the law of the place where the lands are situated, that they refer to the state decision of the case, reported in Cushing, and to many decisions of this court. But this court does not seem to have considered the point of sufficient importance to notice it in their opinions. In Miller v. Austin, an action was brought by the endorsee of a written promise. The question was whether it was negotiable under a statute of Ohio. The Supreme Court of that state having decided it was not negotiable, the plaintiff became non-suit and brought his action in the Circuit Court of the United States. The decision of the Supreme Court of the state was relied on. This court unanimously held the paper to be negotiable. When the decisions of the highest court of a state are directly in conflict with each other, it has been repeatedly held here that the last decision is not necessarily to be taken as the rule. To these considerations, I desire to add that it was not made known to the Supreme Court of Missouri, so far as appears, that the plaintiff was married in Wisconsin with the consent of Dr. Emerson, and it is not made known to us that Dr. Emerson was a citizen of Missouri, a fact to which that court seemed to have attached much importance. Sitting here to administer the law between these parties, I do not feel at liberty to surrender my own convictions of what the law requires to the authority of the decision in Missouri reports. I have thus far assumed merely for the purpose of the argument that the laws of the United States respecting slavery in this territory were constitutionally enacted by Congress. It remains to inquire whether they are constitutional and binding laws. In the argument of this part of the case at bar, it was justly considered by all the counsel to be necessary to ascertain the source of the power of Congress over the territory belonging to the United States. Until this is ascertained, it is not possible to determine the extent of that power. On the one side, it was maintained that the Constitution contains no express grant of power to organize and govern what is now known to the laws of the United States as a territory. That whatever power of this kind exists is derived by implication from the capacity of the United States to hold and acquire territory out of the limits of any state, and the necessity for its having some government. On the other side, it was insisted that the Constitution has not failed to make an express provision for this end, and that it is found in the third section of the fourth article of the Constitution. To determine which of these is the correct view, it is needful to advert to some facts respecting this subject, which existed when the Constitution was framed and adopted. It will be found that these facts not only shed much light on the question whether the framers of the Constitution omitted to make a provision concerning the power of Congress to organize and govern territories, but they will also aid in the construction of any provision which may have been made respecting this subject. Under the Confederation, the unsettled territory within the limits of the United States had been a subject of deep interest. Some of the states insisted that these lands were within their chartered boundaries and that they had succeeded to the title of the Crown to the soil. On the other hand, it was argued that the vacant lands had been acquired by the United States by the war carried on by them under the common government and for the common interest. This dispute was further complicated by unsettled questions of boundary among the several states. It not only delayed the accession of Maryland to the Confederation, but at one time seriously threatened its existence. Under the pressure of these circumstances, Congress earnestly recommended to the several states a cession of their claims and rights to the United States, and before the Constitution was framed, it had been begun. That by New York had been made on the first day of March 1781, that of Virginia on the first day of March 1784, that of Massachusetts on the 19th day of April 1785, that of Connecticut on the 14th day of September 1786, that of South Carolina on the 8th day of August 1787, while the convention for framing the Constitution was in session. It is very material to observe in this connection that each of these acts cedes in terms to the United States as well the jurisdiction as the soil. It is also equally important to note that when the Constitution was framed and adopted, this plan of vesting in the United States for the common good the great tracts of ungranted lands claimed by the several states in which so deep an interest was felt was yet incomplete. It remained for North Carolina and Georgia to cede their extensive and valuable claims. These were made by North Carolina on the 25th day of February 1790 and by Georgia on the 24th day of April 1802. The terms of these last mentioned cessions will hereafter be noticed in another connection, but I observe here that each of them distinctly shows upon its face that they were not only in execution of the general plan proposed by the Congress of the Confederation, but of a formed purpose of each of these states, existing when the assent of their respective people was given to the Constitution of the United States. It appears, then, that when the federal Constitution was framed and presented to the people of the several states for their consideration, the unsettled territory was viewed as justly applicable to the common benefit, so far as it then had or might attain thereafter a pecuniary value, and so far as it might become the seat of new states to be admitted into the Union upon an equal footing with the original states, and also that the relations of the United States to that unsettled territory were of different kinds. The titles of the states of New York, Virginia, Massachusetts, Connecticut, and South Carolina, as well as of soil as of jurisdiction, had been transferred to the United States. North Carolina and Georgia had not actually made transfers, but a confident expectation, founded on their appreciation of the justice of the general claim and fully justified by the results, was entertained that these cessions would be made. The Ordinance of 1787 had made provision for the temporary government of so much of the territory actually ceded as lay northwest of the River Ohio. But it must have been apparent, both to the framers of the Constitution and the people of the several states who were to act upon it, that the government thus provided for could not continue unless the Constitution should confer on the United States the necessary powers to continue it. That temporary government under the ordinance was to consist of certain officers to be appointed by and responsible to the Congress of the Confederation. Their powers had been conferred and defined by the ordinance. So far as it provided for the temporary government of the territory, it was an ordinary act of legislation deriving its force from the legislative power of Congress and depending for its validity or for its vitality upon the continuance of that legislative power. But the officers to be appointed for the Northwestern Territory after the adoption of the Constitution must necessarily be officers of the United States and not of the Congress of the Confederation, appointed and commissioned by the President and exercising powers derived from the United States under the Constitution. Such was the relation between the United States and the Northwestern Territory, which all reflecting men must have foreseen would exist, when the government created by the Constitution should supersede that of the Confederation. That if the new government should be without power to govern this territory, it could not appoint and commission officers, and send them into the territory to exercise their legislative, judicial, and executive power, and that this territory, which was even then foreseen to be so important, both politically and financially, to all the existing states, must be left not only without the control of the general government in respect to its future political relations to the rest of the states, but absolutely without any government save what its inhabitants, acting in their primary capacity, might from time to time create for themselves. But this Northwestern Territory was not the only territory, the soil and jurisdiction whereof were then understood to have been ceded to the United States. The cession by South Carolina, made in August 1787, was of all the territory included within the river Mississippi, and a line beginning at that part of the said river which is intersected by the southern boundary of North Carolina and continuing along the said boundary line until it intersects the ridge or chain of mountains which divides the eastern from the western waters. Then to be continued along the top of the said ridge of mountains until it intersects a line to be drawn due west from the head of the southern branch of the Tugaloo River. To the said mountains, and thence to run a due west course to the river Mississippi. It is true that by subsequent explorations it was ascertained that the source of the Tugaloo River, upon which the title of South Carolina depended, was so far to the northward that the transfer conveyed only a narrow slip of land, about 12 miles wide, lying on the top of the ridge of mountains, and extending from the northern boundary of Georgia to the southern boundary of North Carolina. But this was a discovery made long after the cession, and there can be no doubt that the state of South Carolina, in making the cession, and the Congress in accepting it, viewed it as a transfer to the United States of the soil and jurisdiction of an extensive and important part of the unsettled territory ceded by the Crown of Great Britain by the Treaty of Peace, though its quantity or extent then remained to be ascertained. It must be remembered also, as has been already stated, that not only was there a confident expectation entertained by the other states that North Carolina and Georgia would complete the plan already so far executed by New York, Virginia, Massachusetts, Connecticut, and South Carolina, but that the opinion was in no small degree prevalent that the just title to this back country, as it was termed, had vested in the United States by the Treaty of Peace and could not rightfully be claimed by an individual state. There is another consideration applicable to this part of the subject and entitled, in my judgment, to great weight. The Congress of the Confederation had assumed the power not only to dispose of the lands ceded, but to institute governments and make laws for their inhabitants. In other words, they had proceeded to act under the cession, which, as we have seen, was as well of the jurisdiction as of the soil. This ordinance was passed on the 13th of July, 1787. The convention for framing the Constitution was then in session at Philadelphia. The proof is direct and decisive, that it was known to the convention. It is equally clear that it was admitted and understood not to be within the legitimate powers of the Confederation to pass this ordinance. The importance of conferring on the new government regular powers commensurate with the objects to be attained, and thus avoiding the alternative of a failure to execute the trust assumed by the acceptance of the cessions made and expected, or its execution by usurpation, could scarcely fail to be perceived. That it was in fact perceived is clearly shown by the Federalist number 38, where this very argument is made use of in commendation of the Constitution. Keeping these facts in view, it may confidently be asserted that there is very strong reason to believe, before we examine the Constitution itself, that the necessity of a competent grant of power to hold, dispose of, and govern territory, ceded and expected to be ceded, could not have escaped the attention of those who framed or adopted the Constitution, and that if it did not escape their attention, it could not fail to be adequately provided for. Any other conclusion would involve the assumption that a subject of the gravest national concern, respecting which the small states felt so much jealousy that it had been almost an insurmountable obstacle to the formation of the Confederation, and as to which all the states had deep pecuniary and political interests, and which had been so recently and constantly agitated, was nevertheless overlooked, or that such a subject was not overlooked, but designedly left unprovided for, though it was manifestly a subject of common concern, which belonged to the care of the general government, and adequate provision for which could not fail to be deemed necessary and proper. The admission of new states, to be framed out of the ceded territory, early attracted the attention of the convention. Among the resolutions introduced by Mr. Randolph on the 29th of May was one on this subject, which, having been affirmed in Committee of the Whole on the 5th of June and reported to the Convention on the 13th of June, was referred to the Committee of Detail to prepare the Constitution on the 26th of July. This committee reported an article for the admission of new states, lawfully constituted or established. Nothing was said concerning the power of Congress to prepare or form such states. This omission struck Mr. Madison, who, on the 18th of August, moved for the insertion of power to dispose of the unappropriated lands of the United States and to institute temporary governments for the new states arising therein. On the 29th of August, the report of the committee was taken up, and after debate, which exhibited great diversity of views concerning the proper mode of providing for the subject, arising out of the supposed diversity of interests of the large and small states, and between those which had and those which had not unsettled territory, but no difference of opinion respecting the propriety and necessity of some adequate provision for the subject, Gouverneur Morris moved the clause as it stands in the Constitution. This met with general approbation and was at once adopted. The whole section is as follows. New states may be admitted by the Congress into this union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of two or more states, or parts of states, without the consent of the legislatures of the states concerned, as well as of Congress. The Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States or any particular state. That Congress has some power to institute temporary governments over the territory, I believe all agree, and if it be admitted that the necessity of some power to govern the territory of the United States could not and did not escape the attention of the convention and the people, and that the necessity is so great that, in the absence of any express grant, it is strong enough to raise an implication of the existence of that power, it would seem to follow that it is also strong enough to afford material aid in construing an express grant of power respecting that of territory, and that they who maintain the existence of the power, without finding any words at all in which it is conveyed, should be willing to receive a reasonable interpretation of language of the Constitution manifestly intended to relate to the territory, and to convey to Congress some authority concerning it. It would seem also that when we find the subject matter of the growth and formation and admission of new states and the disposal of the territory for these ends were under consideration and that some provision therefore was expressly made, it is improbable that it would be, in its terms, a grossly inadequate provision, and that an indispensably necessary power to institute temporary governments and to legislate for the inhabitants of the territory was passed silently by and left to be deduced from the necessity of the case. In the argument at the bar, great attention has been paid to the meaning of the word territory. Ordinarily, when the territory of a sovereign power is spoken of, it refers to that tract of country which is under the political jurisdiction of that sovereign power. Thus, Chief Justice Marshall, in the United States v. Bevins, says, "What then is the extent of jurisdiction which a state possesses?" We answer, without hesitation, the jurisdiction of a state is coextensive with its territory. Examples might easily be multiplied of this use of the word, but they are unnecessary because it is familiar. But the word territory is not used in this broad and general sense in this clause of the Constitution. At the time of the adoption of the Constitution, the United States held a great tract of country northwest of the Ohio, another tract then of unknown extent ceded by South Carolina, and a confident expectation was then entertained and afterwards realized that they then were or would become the owners of other great tracts claimed by North Carolina and Georgia. These ceded tracts lay within the limits of the United States and out of the limits of any particular state, and the cession embraced the civil and political jurisdiction and so much of the soil as had not previously been granted to individuals. These words, territory belonging to the United States, were not used in the Constitution to describe an abstraction, but to identify and apply to these actual subjects matter then existing and belonging to the United States and other similar subjects which might afterwards be acquired. And this being so, all the essential qualities and incidents attending such actual subjects are embraced within the words territory belonging to the United States as fully as if each of those essential qualities and incidents had been specifically described. I say the essential qualities and incidents, but in determining what were the essential qualities and incidents of the subject with which they were dealing, we must take into consideration not only all the particular facts which were immediately before them, but the great consideration ever present to the minds of those who framed and adopted the Constitution, that they were making a frame of government for the people of the United States and their posterity, under which they hoped the United States might be what they have now become, a great and powerful nation, possessing the power to make war and to conclude treaties, and thus to acquire territory. With these in view, I turn to examine the clause of the article now in question. It is said this provision has no application to any territory save that then belonging to the United States. I have already shown that when the Constitution was framed, a confident expectation was entertained, which was speedily realized, that North Carolina and Georgia would cede their claims to that great territory which lay west of those states. No doubt has been suggested that the first clause of this same article, which enabled Congress to admit new states, refers to and includes new states to be formed out of this territory, expected to be thereafter ceded by North Carolina and Georgia, as well as new states to be formed out of territory northwest of the Ohio, which then had been ceded by Virginia. It must have been seen, therefore, that the same necessity would exist for an authority to dispose of and make all needful regulations respecting this territory, when ceded, as existed for a like authority respecting territory which had been ceded. No reason has been suggested why any reluctance should have been felt by the framers of the Constitution to apply this provision to all the territory which might belong to the United States, or why any distinction should have been made, founded on the accidental circumstances of the dates of the sessions, a circumstance in no way material as respects the necessity for rules and regulations, or the propriety of conferring on the Congress power to make them. And if we look at the course of the debates in the convention on this article, we shall find that the then unceded lands, so far from having been left out of view in adopting this article, constituted in the minds of members a subject of even paramount importance. Again, in what an extraordinary position would the limitation of this clause to territory then belonging to the United States place the territory which lay within the chartered limits of North Carolina and Georgia? The title of that territory was then claimed by those states and by the United States. Their respective claims are purposely left unsettled by the express words of this clause, and when cessions were made by those states, they were merely of their claims to this territory, the United States neither admitting nor denying the validity of those claims, so that it was impossible then, and has ever since remained impossible, to know whether this territory did or did not then belong to the United States, and consequently to know whether it was within or without the authority conferred by this clause, to dispose of and make rules and regulations respecting the territory of the United States. This attributes to the eminent men who acted on this subject a want of ability and forecast, or a want of attention to the known facts upon which they were acting, in which I cannot concur. There is not, in my judgment, anything in the language, the history, or the subject matter of this article which restricts its operation to territory owned by the United States when the Constitution was adopted. But it is also insisted that provisions of the Constitution respecting territory belonging to the United States do not apply to territory acquired by treaty from a foreign nation. This objection must rest upon the position that the Constitution did not authorize the federal government to acquire foreign territory, and consequently has made no provision for its government when acquired, or that though the acquisition of foreign territory was contemplated by the Constitution, its provisions concerning the admission of new states and the making of all needful rules and regulations respecting territory belonging to the United States were not designed to be applicable to territory acquired from foreign nations. It is undoubtedly true that at the date of the Treaty of 1803 between the United States and France for the cession of Louisiana, it was made a question whether the Constitution had conferred on the executive department of the government of the United States power to acquire foreign territory by a treaty. There is evidence that very grave doubts were then entertained concerning the existence of this power, but that there was then a settled opinion in the executive and legislative branches of the government that this power did not exist, cannot be admitted, without at the same time imputing to those who negotiated and ratified the treaty and passed the laws necessary to carry it into execution a deliberate and known violation of their oaths to support the Constitution. And whatever doubts may then have existed, the question must now be taken to have been settled. 4 distinct acquisitions of foreign territory have been made by as many different treaties, under as many different administrations. 6 states formed on such territory are now in the Union. Every branch of this government, during a period of more than 50 years, has participated in these transactions. To question their validity now is in vain. As was said by Mr. Chief Justice Marshall in the American Insurance Company v. Cantor, the Constitution confers absolutely on the government of the Union the powers of making war and of making treaties. Consequently, that government possesses the power of acquiring territory either by conquest or treaty. And I add, it also possesses the power of governing it, when acquiring, not by resorting to supposititious powers, nowhere found described in the Constitution, but expressly granted in the authority to make all needful rules and regulations respecting the territory of the United States. There was to be established by the Constitution a frame of government under which the people of the United States and their posterity were to continue indefinitely. To take one of its provisions, of the language of which is broad enough to extend throughout the existence of the government and embrace all territory belonging to the United States throughout all time, and the purposes and objects of which apply to all territory of the United States, and narrow it down to territory belonging to the United States when the Constitution was framed, while at the same time it is admitted that the Constitution contemplated and authorized the acquisition from time to time of other and foreign territory, seems to me to be an interpretation as inconsistent with the nature and purpose of the instrument as it is with its language, and I can have no hesitation in rejecting it. I construe this clause, therefore, as if it had read, Congress shall have power to make all needful rules and regulations respecting those tracts of country out of the limits of the several states, which the United States have acquired, or may hereafter acquire by cessions, as well of the jurisdiction as of the soil, so far as the soil may be the property of the party making the cession, at the time of making it. It has been urged that the words rules and regulations are not appropriate terms in which to convey authority to make laws for the government of the territory, but it must be remembered that this is a grant of power to the Congress, that it is therefore necessarily a grant of power to legislate, and certainly rules and regulations respecting a particular subject made by the legislative power of a country can be nothing but laws. Nor do the particular terms employed, in my judgment, tend in any degree to restrict this legislative power. Power granted to a legislature to make all needful rules and regulations respecting the territory is a power to pass all needful laws respecting it. The word regulate or regulation is several times used in the Constitution. It is used in the fourth section of the first article to describe those laws of the states which prescribe the times, places, and manner of choosing senators and representatives. In the second section of the fourth article, to designate the legislative action of a state on the subject of fugitives from service. Having a very close relation to the matter of our present inquiry, in the second section of the third article, to empower Congress to fix the extent of the appellate jurisdiction of this court, and finally, in the eighth section of the first article are the words, Congress shall have power to regulate commerce. It is unnecessary to describe the body of legislation which has been enacted under this grant of power. Its variety and extent are well known. But it may be mentioned in passing that under this power to regulate commerce, Congress has enacted a great system of municipal laws and extended it over the vessels and crews of the United States on the high seas and in foreign ports, and even over citizens of the United States resident in China, and has established judicatures with power to inflict even capital punishment within that country. If then this clause does contain a power to legislate respecting the territory, what are the limits of that power? To this I answer that, in common with all the other legislative powers of Congress, it finds limits in the express prohibitions on Congress not to do certain things, that, in the exercise of the legislative power, Congress cannot pass an ex post facto law or bill of attainder, and so in respect to each of the other prohibitions contained in the Constitution. Besides this, the rules and regulations must be needful, but undoubtedly the question whether a particular or regulation be needful must be finally determined by Congress itself. Whether a law be needful is a legislative or political, not a judicial question. Whatever Congress deems needful is so under the grant of power. Nor am I aware that it has ever been questioned that laws providing for the temporary government of the settlers on the public lands are needful, not only to prepare them for admission to the Union as states, but even to enable the United States to dispose of the lands. Without government and social order, there can be no property, for without law, its ownership, its use, and the power of disposing of it cease to exist in the sense in which those words are used and understood in all civilized states. Since then, this power was manifestly conferred to enable the United States to dispose of its public lands to settlers, and to admit them into the Union as states, when, in the judgment of Congress, they should be fitted therefor, since these were the needs provided for, since it is confessed that government is indispensable to provide for those needs, and the power is to make all needful rules and regulations respecting the territory. I cannot doubt that this is a power to govern the inhabitants of the territory by such laws as Congress deems needful until they obtain admission as states. Whether they should be thus governed solely by laws enacted by Congress or partly by laws enacted by legislative power conferred by Congress is one of those questions which depend on the judgment of Congress, a question which of these is needful. But it is insisted that whatever other powers Congress may have respecting the territory of the United States, the subject of African American slavery forms an exception. The Constitution declares that Congress shall have power to make all needful rules and regulations respecting the territory belonging to the United States. The assertion is, though the Constitution says all, it does not mean all, though it says all without qualification. It means all except such as allow or prohibit slavery. It means all except such as allow or prohibit slavery. It cannot be doubted that it is incumbent on those who would thus introduce an exception not found in the language of the instrument to exhibit some solid and satisfactory reason drawn from the subject matter or the purposes and objects of the clause, the context, or from other provisions of the Constitution, showing that the words employed in this clause are not to be understood according to their clear, plain, and natural signification. The subject matter is the territory of the United States out of the limits of every state and consequently under the exclusive power of the people of the United States. Their will respecting it, manifested in the Constitution, can be subject to no restriction. The purposes and objects of the clause were the enactment of laws concerning the disposal of the public lands and the temporary government of the settlers thereon until new states should be formed. It will not be questioned that when the Constitution of the United States was framed and adopted, the allowance and the prohibition of African American slavery were recognized as subjects of municipal legislation. Every state had in some measure acted thereon, and the only legislative act concerning the territory, the Ordinance of 1787, which had then so recently been passed, contained a prohibition of slavery. The purpose and object of the clause being to enable Congress to provide a body of municipal law for the government of the settlers, the allowance or the prohibition of slavery comes within the known and recognized scope of that purpose and object. There is nothing in the context which qualifies the grant of power. The regulations must be respecting the territory. An enactment that slavery may or may not exist there is a regulation respecting the territory. Regulations must be needful, but it is necessarily left to the legislative discretion to determine whether a law be needful. No other clause of the Constitution has been referred to at the bar, or has been seen by me, which imposes any restriction or makes any exception concerning the power of Congress to allow or prohibit slavery in the territory belonging to the United States. A practical construction, nearly contemporaneous with the adoption of the Constitution and continued by repeated instances through a long series of years, may always influence, and in doubtful cases should determine, the judicial mind on a question of the interpretation of the Constitution. In this view, I proceed briefly to examine the practical construction placed on the clause now in question, so far as it respects the inclusion therein of power to permit or prohibit slavery in the territories. It has already been stated that after the government of the United States was organized under the Constitution, the temporary government of the territory northwest of the River Ohio could no longer exist, save under the powers conferred on Congress by the Constitution. Whatever legislative, judicial, or executive authority should be exercised therein could be derived only from the people of the United States under the Constitution, and accordingly, an act was passed on the 7th day of August 1789, which recites, "Whereas, in order that the ordinance of the United States in Congress assembled for the government of the territory northwest of the River Ohio may continue to have full effect, it is required that certain provisions should be made so as to adapt the same to the present Constitution of the United States. It then provides for the appointment by the President of all officers who, by force of the ordinance, were to have been appointed by the Congress of the Confederation, and their commission in the manner required by the Constitution, and empowers the Secretary of the Territory to exercise the powers of the Governor in case of the death or necessary absence of the latter." Here is an explicit declaration of the will of the First Congress, of which 14 members, including Mr. Madison, had been members of the convention which framed the Constitution, that the ordinance, one article of which prohibited slavery, should continue to have full effect. General Washington, who signed this bill as president, was the president of that convention. It does not appear to me to be important in this connection that clause in the ordinance which prohibited slavery was one of a series of articles of what is therein termed a compact. The Congress of the Confederation had no power to make such a compact, nor to act at all on the subject. And after what had been so recently said by Mr. Madison on this subject in the 38th number of the Federalist, I cannot suppose that one or any others who voted for this bill attributed any intrinsic effect to what was denominated in the ordinance a compact between the original states and the people and states in the new territory. there being no new states then in existence in the territory with whom a compact could be made, and the few scattered inhabitants, unorganized into a political body, not being capable of becoming a party to a treaty, even if the Congress of the Confederation had had power to make one touching the government of that territory. I consider the passage of this law to have been an assertion by the first Congress of the power of the United States to prohibit slavery within this part of the territory of the United States, for it clearly shows that slavery was thereafter to be prohibited there, and it could be prohibited only by an exertion of the power of the United States under the Constitution, no other power being capable of operating within that territory after the Constitution took effect. On the 2nd of April, 1790, the first Congress passed an act accepting a deed of cession by North Carolina of that territory afterwards erected into the state of Tennessee. The fourth express condition contained in this deed of cession, after providing that the inhabitants of the territory shall be temporarily governed in the same manner as those beyond the Ohio, is followed by these words: provided always that no regulation made or to be made by Congress shall tend to emancipate slaves. This provision shows that it was then understood Congress might make a regulation prohibiting slavery, and that Congress might also allow it to continue to exist in the territory. And accordingly, when a few years later, Congress passed the Act of May 20th, 1790, for the government of the territory south of the River Ohio. It provided, and the government of the territory south of the Ohio shall be similar to that now exercised in the territory northwest of the Ohio, except so far as is otherwise provided in the conditions expressed in an act of Congress of the present session, entitled An Act to Accept a Cession of the Claims of the State of North Carolina to a Certain District of Western Territory. Under the government thus established, slavery existed until the territory became the state of Tennessee. On the 7th of April, 1798, an act was passed to establish a government in the Mississippi Territory, in all respects like that exercised in the territory northwest of the Ohio, excepting and excluding the last article of the ordinance made for the government thereof by the late Congress on the 13th day of July, 1787. When the limits of this territory had been amicably settled with Georgia, and the latter ceded all its claim thereto, it was one stipulation in the compact of cession that the ordinance of July 13th, 1787, shall in all its parts extend to the territory contained in the present act of cession, that article only excepted which forbids slavery. The government of this territory was subsequently established and organized under the act of May 10th, 1800. But so much of the ordinance as prohibited slavery was not put in operation there. Without going minutely into the details of each case, I will now give reference to two classes of acts, in one of which Congress has extended the ordinance of 1787, including the article prohibiting slavery, over different territories, and thus exerted its power to prohibit it. In the other, Congress has erected governments over territories acquired from France and Spain, in which slavery already existed, but refused to apply to them that part of the government under the ordinance which excluded slavery. For the government of the Indiana Territory, the Act of January 11th, 1805. For the government of Michigan Territory, the Act of May 3rd, 1809. For the government of the Illinois Territory, the Act of the Act of April 20th, 1836. And for the government of the Territory of Wisconsin, the Act of June 12th, 1838. And for the government of the Territories of Iowa, the Act of August 14th, 1848. For the government of the Territory of Oregon. To these instances should be added the Act of March 6, 1820, prohibiting slavery in the territory acquired from France, being northwest of Missouri and north of 36 degrees 30 minutes north latitude. Of the second class, in which Congress refused to interfere with slavery already existing under the municipal law of France or Spain, and established governments by which slavery was recognized and allowed, are the Act of March 26, 1804, for the government of Louisiana, the Act of March 2nd, 1805, for the government of the Territory of Orleans, the Act of June 4th, 1812, for the government of the Missouri Territory, the Act of March 30th, 1822, for the government of the Territory of Florida. Here are 8 distinct instances, beginning with the first Congress and coming down to the year 1848, in which Congress has excluded slavery from the territory of the United States, and 6 distinct instances in which Congress organized governments of territories by which slavery was recognized and continued, beginning also with the first Congress and coming down to the year 1822. These acts were severally signed by 7 presidents of the United States, beginning with General Washington and coming regularly down as far as Mr. John Quincy Adams, thus including all who were in public life when the Constitution was adopted. If the practical construction of the Constitution contemporaneously with its going into effect by men intimately acquainted with its history from their personal participation in framing and adopting it, and continued by them through a long series of acts of the gravest importance, be entitled to weight in the judicial mind on a question of construction, it would seem to be difficult to resist the force of the acts above adverted to. It appears, however, from what has taken place at the bar, that notwithstanding the language of the Constitution and the long line of legislative and executive precedents under it, 3 different and opposite views were taken of the power of Congress respecting slavery in the territories. One is that though Congress can make a regulation prohibiting slavery in a territory, they cannot make a regulation allowing it. Another is that it can neither be established nor prohibited by Congress, but that the people of a territory, when organized by Congress, can establish or prohibit slavery, while the third is that the Constitution itself secures to every citizen who holds slaves under the laws of any state the indefeasible right to carry them into any territory and there hold them as property. No particular clause of the Constitution has been referred to at the bar in support of either of these views. The first seems to be rested upon general considerations concerning the social and moral evils of slavery, its relations to republican governments, its inconsistency with the Declaration of Independence, and with natural right. The second is drawn from considerations equally general, concerning the right of self government and the nature of the political institutions which have been established by the people of the United States, while the third is said to rest upon the equal right of all citizens to go with their property upon the public domain, and the inequality of a regulation which would admit the property of some and exclude the property of other citizens. And inasmuch as slaves are chiefly held by citizens of those particular states where slavery is established, it is insisted that a regulation excluding slavery from a territory operates practically to make an unjust discrimination between citizens of different states in respect to their use and enjoyment of the territory of the United States. With the weight of either of these considerations, when presented to Congress to influence its action, this court has no concern. One or the other may be justly entitled to guide or control the legislative judgment upon what is a needful regulation. The question here is whether they are sufficient to authorize this court to insert into this clause of the Constitution an exception of the exclusion or allowance of slavery, not found therein, nor in any other part of that instrument. To engraft on any instrument a substantive exception not found in it must be admitted to be a matter attended with great difficulty, and the difficulty increases with the importance of the instrument and the magnitude and complexity of the interests involved in its construction. To allow this to be done with the Constitution upon reasons purely political renders its judicial interpretation impossible, because judicial tribunals, as such, cannot decide upon political considerations. Political reasons have not the requisite certainty to afford rules of jurisdictional interpretation. Juridical interpretation. They are different in different men. They are different in the same men at different times. And when a strict interpretation of the Constitution, according to the fixed rules which govern the interpretation of laws, is abandoned, and the theoretical opinions of individuals are allowed to control its meaning, we have no longer a Constitution. We are under the government of individual men, who, for the time being, have power to declare what the Constitution is, according to their own views of what it ought to mean. When such a method of interpretation of the Constitution obtains in place of a republican government with limited and defined powers, we have a government which is merely an exponent of the will of Congress, or what, in my opinion, would not be preferable, an exponent of the individual political opinions of the members of this court. If it can be shown by any anything in the Constitution itself, that when it confers on Congress the power to make all needful rules and regulations respecting the territory belonging to the United States, the exclusion or the allowance of slavery was accepted. Or if anything in the history of this provision tends to show that such an exception was intended by those who framed and adopted the Constitution to be introduced into it. I hold it to be my duty carefully to consider and to allow just weight to such considerations in interpreting the positive text of the Constitution. But where the Constitution has said all needful rules and regulations, I must find something more than theoretical reasoning to induce me to say it did not mean all. There have been eminent instances in this court closely analogous to this one, in which such an attempt to introduce an exception not found in the Constitution itself has failed of success. By the eighth section of the first article, Congress has the power of exclusive legislation in all cases whatsoever within this district. In the case of Loughborough v. Blake, the question arose whether Congress has power to impose direct taxes on persons and property in this district. It was insisted that though the grant of power was in its terms broad enough to include direct taxation, it must be limited by the principle that taxation and representation are inseparable. It would not be easy to fix on any political truth better established or more fully admitted in our country than that taxation and representation must exist together. We went into the War of the Revolution to assert it, and it is incorporated as fundamental into all American governments. But however true and important this maxim may be, it is not necessarily of universal application. It was for the people of the United States, who ordained the Constitution, to decide whether it should or should not be permitted to operate within this district. Their decision was embodied in the words of the Constitution, and as that contained no such exception as would permit the maximum to operate in this district, this court, interpreting that language, held that the exception did not exist. Again, the Constitution confers on Congress power to regulate commerce with foreign nations. Under this, Congress passed an act on the 22nd of December, 1807, unlimited in duration, laying an embargo on all ships and vessels in the ports or within the limits and jurisdiction of the United States. No law of the United States ever pressed so severely upon particular states. Though the constitutionality of the law was contested with an earnestness and zeal proportioned to the ruinous effects which were felt from it, and though, as Mr. Chief Justice Marshall has said, a want of acuteness in discovering objections to a measure to which they felt the most deep-rooted hostility will not be imputed to those who were arrayed in opposition to this. I am not aware that the fact that it prohibited the use of a particular species of property belonging almost exclusively to citizens of a few states, and this indefinitely, was ever supposed to show that it was unconstitutional. Something much more stringent, as a ground of legal judgment, was relied on, that the power to regulate commerce did not include the power to annihilate commerce. But the decision was that under the power to regulate commerce, the power of Congress over the subject was restricted only by those exceptions and limitations contained in the Constitution, and as neither the clause in question, which was a general grant of power to regulate commerce, nor any other clause of the Constitution imposed any restrictions as to the duration of an embargo, an unlimited prohibition of the use of the shipping of the country was within the power of Congress. On this subject, Mr. Justice Daniel, speaking for the court in the case of United States v. Marigold, says, Congress are, by the Constitution, vested with the power to regulate commerce with foreign nations, and however, at periods of high excitement, an application of the terms to regulate commerce, such as would embrace absolute prohibition, may have been questioned. Yet, since the passage of the embargo and non-intercourse laws, and the repeated judicial sanctions these statutes have received, it can scarcely at this day be open to doubt that every subject falling legitimately within the sphere of commercial regulation may be partially or wholly excluded, when either measure shall be demanded by the safety or the important interests of the entire nation. The power once conceded, it may operate on any and every subject of commerce to which the legislative discretion may apply it. If power to regulate commerce extends to an indefinite prohibition of the use of all vessels belonging to citizens of the several states, and may operate without exception upon every subject of commerce to which the legislative discretion may apply it. Upon what grounds can I say that power to make all needful rules and regulations respecting the territory of the United States is subject to an exception of the allowance or prohibition of slavery therein? While the regulation is one respecting the territory, while it is, in the judgment of Congress, a needful regulation, and is thus completely within the words of the grant, while no other clause of the Constitution can be shown, which requires the insertion of an exception respecting slavery, and while the practical construction for a period of upwards of 50 years forbids such an exception, it would, in my opinion, violate every sound rule of interpretation to force that exception into the Constitution upon the strength of abstract political reasoning, which we are bound to believe the people of the United States thought insufficient to induce them to limit the power of Congress, because what they have said contains no such limitation. Before I proceed further to notice some other grounds of supposed objection to this power of Congress, I desire to say that if it were not for my anxiety to insist upon what I deem a correct exposition of the Constitution, if I looked only to the purpose of the argument, the source of the power of Congress asserted in the opinion of the majority of the court would answer those purposes equally well, for they admit that Congress has power to organize and govern the territories until they arrive at a suitable condition for admission to the Union. They admit also that the kind of government which shall thus exist should be regulated by the condition and wants of each territory, and that it is necessarily committed to the discretion of Congress to enact such laws for that purpose as that discretion may dictate, and no limit to that discretion has been shown or even suggested, save those positive prohibitions to legislate, which are found in the Constitution. I confess myself unable to perceive any difference whatever between my own opinion of the general extent of the power of Congress and the opinion of the majority of the court, save that I consider it derivable from the express language of the Constitution, while they hold it to be silently implied from the power to acquire territory. Looking at the power of Congress over the territories as of the extent just described, what positive prohibition exists in the Constitution which restrained Congress from enacting a law in 1820 to prohibit slavery north of 36 degrees 30 minutes north latitude? The only one suggested is that clause in the fifth article of the amendments of the Constitution, which declares that no person shall be deprived of his life, liberty, or property without due process of law. I will now proceed to examine the question whether this clause is entitled to the effect thus attributed to it. It is necessary first to have a clear view of the nature and incidence of that particular species of property which is now in question. Slavery, being contrary to natural right, is created only by municipal law. This is not only plain in itself, and agreed by all writers on the subject, but is inferable from the Constitution, and has been explicitly declared by this court. The Constitution refers to slaves as persons held to service in one state under the laws thereof. Nothing can more clearly describe a status created by municipal law. In Prigg v. Pennsylvania, this court said, the state of slavery is deemed to be a mere municipal regulation, founded on and limited to the range of territorial laws. In Rankin v. Lydia, the Supreme Court of Appeals of Kentucky said, slavery is sanctioned by the laws of this state, and the right to hold them under our municipal regulations is unquestionable. But we view this as a right existing by positive law of a municipal character, without foundation in the law of nature or the unwritten common law. I am not acquainted with any case or writer questioning the correctness of this doctrine. The status of slavery is not necessarily always attended with the same powers on the part of the master. The master is subject to the supreme power of the state, whose will controls his action towards his slave, and this control must be defined and regulated by the municipal law. In one state, as at one period of the Roman law, it may put the life of the slave into the hand of the master. Others, as those of the United States, which tolerate slavery, may treat the slave as a person, when the master takes his life, while in others the law may recognize a right of the slave to be protected from cruel treatment. In other words, the status of slavery embraces every condition from that in which the slave is known to the law simply as a chattel with no civil rights, to that in which he is recognized as a person for all purposes, save the compulsory power of directing and receiving the fruits of his labor. Which of these conditions shall attend the status of slavery must depend on the municipal law which creates and upholds it. And not only must the status of slavery be created and measured by municipal law, but the rights, powers, and obligations which grow out of that status must be defined, protected, and enforced by such laws. The liability of the master for the torts and crimes of his slave and of third persons for assaulting or injuring or harboring or kidnapping him, the forms and modes of emancipation and sale, their subjection to the debts of the master, succession by death of the master, suits for freedom, the capacity of the slave to be party to a suit or to be a witness, with such police regulations as have existed in all civilized states where slavery has been tolerated, are among the subjects upon which municipal legislation becomes necessary when slavery is introduced. It is conceivable that the Constitution has conferred the right on every citizen to become a resident on the territory of the United States with his slaves, and there to hold them as such, but has neither made nor provided for any municipal regulations which are essential to the existence of slavery. It is not more rational to conclude that they who framed and adopted the Constitution were aware that persons held to service under the laws of a state are property only to the extent and under the conditions fixed by those laws, that they must cease to be available as property when their owners voluntarily place them permanently within the jurisdiction where no municipal laws on the subject of slavery exist, and that being aware of these principles, and having said nothing to interfere with or displace them, or to compel Congress to legislate in any particular manner on the subject, and having empowered Congress to make all needful rules and regulations respecting the territory of the United States, it was their intention to leave to the discretion of Congress what regulations, if any, should be made concerning slavery therein. Moreover, if the right exists, what are its limits, and what are its conditions? If citizens of the United States have the right to take their slaves to a territory and hold them there as slaves without regard to the laws of the territory, I suppose this right is not to be restricted to the citizens of slaveholding states. A citizen of a state which does not tolerate slavery can hardly be denied the power of doing the same thing. And what law of slavery does either take with him to the territory? If it be said to be those laws respecting slavery which existed in the particular state from which each slave last came, what an anomaly is this! Where else can we find, under the law of any civilized country, the power to introduce and permanently continue diverse systems of foreign municipal law for holding persons in slavery? I say not merely to introduce, but permanently to continue these anomalies. For the offspring of the female must be governed by the foreign municipal laws to which the mother was subject, and when any slave is sold or passes by succession on the death of the owner, there must pass with him by a species of subrogation, and as a kind of unknown jus in re, the foreign municipal laws which constituted, regulated, and preserved the status of the slave before his exportation. Whatever theoretical importance may be now supposed to belong to the maintenance of such a right, I feel a perfect conviction that it would, if ever tried, prove to be an impracticable in fact, as it is, in my judgment, monstrous in theory. I consider the assumption which lies at the basis of this theory to be unsound, not in its just sense, but when properly understood, but in the sense which has been attached to it. That assumption is that the territory ceded by France was acquired for the equal benefit of all the citizens of the United States. I agree to that position, but it was acquired for their benefit in their collective, not their individual, capacities. It was acquired for their benefit as an organized political society, subsisting as the people of the United States, under the Constitution of the United States, to be administered justly and impartially, and as nearly as possible for the equal benefit of every individual citizen, according to the best judgment and discretion of the Congress, to whose power, as the legislature of the nation which acquired it, the people of the United States have committed its administration. Whatever individual claims may be founded on local circumstances or sectional differences of condition cannot, in my opinion, be recognized in this court without arrogating to the judicial branch of the government powers not committed to it, and which, with all the unaffected respect I feel for it, when acting in its proper sphere, I do not think it fitted to wield. Nor, in my judgment, will the position that a prohibition to bring slaves into a territory deprives anyone of his property without due process of law bear examination. It must be remembered that this restriction on the legislative power is not peculiar to the Constitution of the United States. It was borrowed from the Magna Carta, which was brought to America by our ancestors as part of their inherited liberties, as has existed in all the states, usually in the very words of the Great Charter. It existed in every political community in America in 1787 when the ordinance prohibiting slavery north and west of the Ohio was passed. And if a prohibition of slavery in a territory in 1820 violated this principle of Magna Carta, the Ordinance of 1787 also violated it. And what power had, I do not say the Congress of the Confederation alone, but the legislature of Virginia or the legislature of any or all the states of the Confederacy to consent to such a violation? The people of the states had conferred no such power. I think I may at least say, if the Congress did then violate Magna Carta, by the ordinance no one discovered that violation. Besides, if the prohibition upon all persons, citizens as well as others, to bring slaves into a territory, and a declaration that if brought they shall be free, deprives citizens of their property without due process of law, what shall we say of the legislation of many of the slaveholding states which have enacted the same prohibition? As early as October 1778, a law was passed in Virginia that thereafter no slave should be imported into that commonwealth by sea or by land, and that every slave who should be imported should become free. A citizen of Virginia purchased in Maryland a citizen of Virginia purchased in Maryland a slave who belonged to another citizen of Virginia, and removed with the slave to Virginia. The slave sued for her freedom and recovered it, as may be seen in Wilson v. Isabel. And then see also Hunter v. Hulsher. And a similar law has been recognized as valid in Maryland in Stewart v. Oaks. I am not aware of that such laws, though they exist in many states, were ever supposed to be in conflict with the principle of Magna Carta incorporated into the state constitutions. It was certainly understood by the convention, which framed the Constitution, and has been so understood ever since, that under the power to regulate commerce, Congress could prohibit the importation of slaves, and the exercise of the power was restrained till 1808. A citizen of the United States owns slaves in Cuba and brings them to the United States, where they are set free by the legislation of Congress. Does this legislation deprive him of his property without due process of law? If so, what becomes of the laws prohibiting the slave trade? If not, how can a similar regulation respecting a territory violate the Fifth Amendment of the Constitution? Some reliance was placed by the defendant's counsel upon the fact that the prohibition of slavery in this territory was in the words that slavery shall be and is hereby forever prohibited. But the insertion of the word forever can have no legal effect. Every enactment not expressly limited in its duration continues in force until repealed or abrogated by some competent power, and the use of the word forever can give to the law no more durable operation. The argument is that Congress cannot so legislate as to bind the future states formed out of the territory, and that in this instance it has attempted to do so. Of the political reasons which may have induced the Congress to use these words, and which caused them to expect that subsequent legislatures would conform their actions to the then general opinion of the country that it ought to be permanent, this court can take no cognizance. However fit such considerations are to control the action of Congress, and however reluctant a statesman may be to disturb what has been settled, every law made by Congress may be repealed, and, saving private rights and public rights gained by states, its repeal is subject to the absolute will of the same power which enacted it. If Congress had enacted that the crime of murder committed in this Indian territory north of 36 degrees 30 minutes by or on any white man should forever be punishable with death, it would seem to me an insufficient objection to an indictment found while it was a territory that at some future day states might exist there, and so the law was invalid because by its terms it was to continue in force forever. Such an objection rests upon a misapprehension of the province and power of courts respecting the constitutionality of laws enacted by the legislature. If the Constitution prescribe one rule and the law another and different rule, it is the duty of courts to declare that the Constitution and not the law governs the case before them for judgment. If the law include no case save those for which the Constitution has furnished a different rule, or no case which the legislature has the power to govern, then the law can have no operation. If it includes cases which the legislature has power to govern and concerning which the Constitution does not prescribe a different rule, the law governs those cases, though it may, in its terms, attempt to include others, on which it cannot operate. In other words, this court cannot declare void an act of Congress which constitutionally embraces some cases, though other cases within its terms are beyond the control of Congress or beyond the reach of that particular law. If, therefore, Congress had power to make a law excluding slavery from this territory while under the exclusive power of the United States, the use of the word forever does not invalidate the law, so long as Congress has the exclusive legislative power in the territory. But it is further insisted that the Treaty of 1803 between the United States and France, by which this territory was acquired, has so restrained the constitutional powers of Congress that it cannot, by law, prohibit the introduction of slavery into that part of this territory north and west of Missouri, and north of 36 degrees 30 minutes north, by north latitude. By a treaty with a foreign nation, the United States may rightfully stipulate that the Congress will or will not exercise its legislative power in some particular manner on some particular subject. Such promises, when made, should be voluntarily kept with the most scrupulous good faith, but that a treaty with a foreign nation can deprive the Congress of any part of the legislative power conferred by the people, so that it no longer can legislate as it was empowered by the Constitution to do, I more than doubt. The powers of the government do and must remain unimpaired. The responsibility of the government to a foreign nation for the exercise of those powers is quite another matter. That responsibility is to be met and justified to the foreign nation according to the requirements of the rules of public law, but never upon the assumption that the United States had parted with or restricted any power of acting according to its own free will, governed solely by its own appreciation of its duty. The second section of the fourth article is, This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. This has made treaties part of our municipal law, but it has not assigned to them any particular degree of authority, nor declared that laws so enacted shall be irrepealable. No supremacy is assigned to treaties over acts of Congress. That they are not perpetual and must be in some way repealable, all will agree. If the President and the Senate alone possess the power to repeal or modify a law found in a treaty, inasmuch as they can change or abrogate one treaty only by making another inconsistent with the first, the government of the United States could not act at all to that effect without the consent of some foreign government. I am not aware it has ever been considered that the Constitution has placed our country in this helpless condition. The action of Congress in repealing the treaties with France by the Act of July 7, 1798, was in conformity with these views. In the case of Taylor v. Morton, I had occasion to consider this subject, and I adhered to the views there expressed. If, therefore, if it were admitted that the treaty between the United States and France did contain an express stipulation that the United States would not exclude slavery from so much of the ceded territory as is now in question, this court could not declare that an act of Congress excluding it was void by force of the treaty, whether or no a case existed sufficient to justify a refusal to execute such stipulation would not be a judicial but a political and legislative question, wholly beyond the authority of this court to try and determine. It would belong to diplomacy and legislation, and not to the administration of existing laws. Such a stipulation in a treaty, to legislate or not to legislate in a particular way, has been repeatedly held in this court to address itself to the political or the legislative power, by whose action thereon this court is bound. But in my judgment, this treaty contains no stipulation in any manner affecting the action of the United States respecting the territory in question. Before examining the language of the treaty, it is material to bear in mind that the part of the ceded territory lying north of 36 degrees 30 minutes and west and north of the present state of Missouri was then a wilderness, uninhabited save by savages whose possessory title had not then been extinguished. It is impossible for me to conceive on what ground France could have advanced a claim, or could have desired to advance a claim, to restrain the United States from making any rules and regulations respecting this territory, which the United States might think fit to make. And still less can I conceive of any reason which would have induced the United States to yield to such a claim. It was to be expected that France would desire to make the change of sovereignty and jurisdiction as little burdensome as possible to the then inhabitants of Louisiana, and might well exhibit even an anxious solicitude to protect their property and persons, and secure to them and their posterity their religious and political rights, and the United States, as a just government, might readily accede to all proper stipulations respecting those who were about to have their allegiance transferred. But what interest France could have in uninhabited territory, which, in the language of the treaty, was to be transferred forever and in full sovereignty to the United States, or how the United States could consent to allow a foreign nation to interfere in its purely internal affairs, in which that foreign nation had no concern whatever, is difficult for me to conjecture. In my judgment, this treaty contains nothing of the kind. The third article is supposed to have a bearing on the question. It is as follows: the inhabitants of the ceded territory shall be incorporated in the Union of the United States and admitted as soon as possible, according to the principles of the federal Constitution, to the enjoyment of all the rights, advantages, and immunities of citizens of the United States, and in the meantime they shall be maintained and protected in the enjoyment of their liberty, property, and their religion they profess. There are two views of this article, each of which I think decisively shows that it was not intended to restrain the Congress from excluding slavery from that part of the ceded territory then uninhabited. The first is that manifestly its sole object was to protect individual rights of the then inhabitants of the territory. They are to be maintained and protected in the free enjoyment of their liberty, property, and the religion they profess. But this article does not secure to them the right to go upon the public domains ceded by the treaty, either with or without their slaves. The right or power of doing this did not exist before or at the time the treaty was made. The French and Spanish governments, while they held the country as well as the United States when they acquired it, always exercised the undoubted right of excluding inhabitants from the Indian country, and of determining when and on what conditions it should be opened to settlers, and a stipulation that the then inhabitants of Louisiana should be protected in their property can have no reference to their use of that property, where they had no right under the treaty to go with it save at the will of the United States. If one who was an inhabitant of Louisiana at the time of the treaty had afterward taken property then owned by him, consisting of firearms, ammunition, and spirits, and had gone into the Indian country north of 36 degrees 30 minutes to sell them to the Indians, all must agree the third article of the treaty would not have protected him from indictment under the Act of Congress of March 30th, 1802. Besides, whatever rights were secured were individual rights. If Congress should pass any law which violates such rights of any individual, and those rights were of such a character as not to be within the lawful control of Congress under the Constitution, that individual could complain, and the act of Congress, as to such rights of his, would be inoperative. But it would be invalid and operative. But it would be valid and operative as to all persons whose individual rights did not come under the protection of the treaty. And, inasmuch as it does not appear that any inhabitant of Louisiana whose rights were secured by treaty had been injured, it would be wholly inadmissible for this court to assume, first, that one or more such cases may have existed, and second, that if any did exist, the entire law was void, not only as to these cases, if any, in which it could not rightfully operate, but as to all others wholly unconnected with the treaty in which such law could rightfully operate. But it is quite unnecessary, in my opinion, to pursue this inquiry further, because it clearly appears from the language of the article, and it has been decided by this court, that the stipulation was temporary and ceased to have any effect when the then inhabitants of the territory of Louisiana, in whose behalf the stipulation was made, were incorporated into the Union. In the case of New Orleans v. de Armas, the question was whether a title to property which existed at the date of the treaty continued to be protected by the treaty after the state of Louisiana was admitted to the Union. The third article of the treaty was relied on. Mr. Chief Justice Marshall said, "This article obviously contemplates two objects. One, that Louisiana shall be admitted into the Union as soon as possible on an equal footing with the other states, and the other, that till such admission and the inhabitants of the ceded territory shall be protected in the free enjoyment of their liberty, property, and religion. Had any one of these rights been violated while these stipulations continued in force, the individual supposing himself to be injured might have brought this case into this court under the 25th section of the Judicial Act. But this stipulation ceased to operate when Louisiana became a member of the Union, and its inhabitants were admitted to the enjoyment of all the rights, advantages, and immunities of citizens of the United States. The cases of Chouteau and v. Marguerita, Marguerita and Permoli v. New Orleans are in conformity with this view of the treaty. To convert this temporary stipulation of the treaty in behalf of French subjects who then inhabited a small portion of Louisiana into a permanent restriction upon the power of Congress to regulate territory then uninhabited, and to assert that it not only restrains Congress from affecting the rights of property of the then inhabitants, but enabled them and all other citizens of the United States to go into any part of the ceded territory with their slaves and hold them there, is a construction of this treaty so opposed to its natural meaning and so far beyond its subject matter and the evident design of the parties that I cannot assent to it. In my opinion, this treaty has no bearing on the present question. For these reasons, I am of the opinion that so much of the several acts of Congress as prohibited slavery and involuntary servitude within that part of the territory of Wisconsin, lying north of 36 degrees 30 minutes north latitude and west of the river Mississippi, were constitutional and valid laws. I have expressed my opinion and the reasons therefore at far greater length than I could have wished upon the different questions on which I have found it necessary to pass, to arrive at a judgment on the case at bar. These questions are numerous, and the grave importance of some of them required me to exhibit fully the grounds of my opinion. I have touched no question which, in the view I have taken, it was not absolutely necessary for me to pass upon, to ascertain whether the judgment of the circuit court should stand or be reversed. I have avoided no question on which the validity of that judgment depends. To have done either more or less would have been inconsistent with my views of my duty. In my opinion, the judgment of the circuit court should be reversed, and the cause remanded for new trial. Well, that was a good read. And as always, if there's any case you'd like me to read, just drop in the comments and I'm happy to take a look. Thank you.